Hello, and so in looking at negligence, the first strand we look at in negligence is duty of care. Now, as my video on what is occupiers liability shows, is that sometimes this duty of care can be established by something other than existing precedent or the Caparo incremental threefold test. So in the case of occupiers liability, this is where duty of care arises from the harm taking place on the premises of the defendant, i.e. the defendant occupies that premise. So let us start with the two acts that govern occupiers liability. You have the Occupiers Liability Act 1957 and 1964. 1957 is the one we're going to look at in this video, and it's in respect to lawful visitors, i.e. those who are not trespassers. So what is the purpose of the Act? Well, Section 11A says that this Act abolishes common law categories and provides that all lawful entrants are owed the same common duty of care in respect to the dangers to the state of the premises or things done or to be omitted on them. And so by this, what we're trying to say is that before the Act came, common law used to afford a high degree of protection to those who had a contractual reason to be on the premise as opposed to other types of lawful visitors. And now with the Act, everybody has a common duty of care. And who is this common duty of care owed by? I.e. the question is, who is the owner? And so Section 1.2 provides that an occupier is a person who would have been treated as such as common law requires. So we have to go back to common law now. And the case of authority on this is Wheat and Lake in 1966. Basically, it's to do at a public house, and you had the owner, then you had the manager, and then you had a guest who there was inadequate lighting on the stairway, and the person fell and he died. So it was saying who is the occupier, i.e. is it the owners who should have been held accountable for this, or is it the manager? And what the House of Lords held is in determining who the occupier was, the question was who had a sufficient degree of control, such that he ought to be under duty of care to those who lawfully came on his premises. And applying this test, the court said that both the owners and the manager in this case were occupied, because you can have more than one occupier, as Lord Denning makes clear. Similarly, in AMF International Limited and Magnet Bowling 1968, both the owners and the contractors were occupiers. Why? Because they both afforded a sufficient degree of control. Now, when one person has a right of occupation, but the owner still has the right to do the repairs, etc., because you have a landlord-tenant situation, the owner is still liable there, even though he might not have occupancy rights, and this is like an exception. And the reason is because the Defective Premises Act 1972, Section 4, it makes the owner liable to take reasonable care for the safety of those present on the premises, so not just those occupiers, but those other lawful entrants onto the occupier. Now, before we can progress, we need to look at what is a premise, because we're all assuming here that premises refers to some kind of land or a house or a building, when actually it's not, because Section 1.3a makes it clear that any fixed or movable structure, including a vessel, vehicle, or aircraft, can be a premises. So do note that occupiers liability extends above houses, buildings, places used for commercial practices to these other movable types of infrastructure. So then now this question is specific to the 1957 Act. Who is a visitor? Well, Section 1.2 states that a visitor is a person who at common law would have been treated as an invitee or licensee. And what used to happen in common law is, as I said, there used to be a hierarchy. The people who had contractual relations were held to have a high degree of protection than those who were, say, an invitee. Now this is gone. We have a common duty of care, but all these people are still lawful visitors. But just because there's a common duty of care, it doesn't mean that the range of persons who are to be treated as visitors has in any way expanded. So Section 2.6 says that persons who enter premises for any purposes in the exercise of a right conferred by law are to be treated as a lawful visitor. So it's not going to expand. It's just that previously in common law we had these different categories. Now they all merged into a common duty of care as a lawful visitor, but this does not mean that the lawful visitor quantity has increased in any way. For example, those who were using a public or private right of way, they weren't treated as invitees or licensees or who had contractual relations, thus they're not treated as lawful visitors. And if you're relying on an implied permission to be a lawful visitor, then the onus is on you, the person asserting it, to prove that you had implied permission. And this is made clear in the case of Edwards and Railway Executive 1952. So it is clear that a license, whether express or implied, can also be withdrawn at any point. So just because you have the license at some point doesn't mean that it can't be withdrawn. So what you need to show is that the owner took no steps to keep the visitors out. So now we can look at two contrasting cases. You have Lowry and Walker 1911, where basically very often this horse used to use the defendant's field as a shortcut, and what the defendant never took any steps to keep the horse out, i.e. they had implied permission to be there. Whereas in Edwards and Railway Executive, there was mere knowledge that there was, I think, children who were trying to come into the land, but defendant had repeatedly tried to fence away the railway line, i.e. so there was no duty and they were not a lawful visitor because, they had been trying to keep it out and there was no implied permission. So we can talk more about the limitations on what makes you a lawful visitor. So even if you have a lawful reason or permission to be in a building, this can be limited by time, space, or circumstance. So as Scruton L.J. said in the Calogarth 1927, he said, when you invite a person into your house to use the stairs, you do not invite him to slide down the banisters. It shows that when you're relying on permission to be in a particular space, it is bound by limitations in time, space, and circumstances. So when you're trying to put across a case for duty, you have to recognize that yes, there might be permission, but there are limitations, and do you come under those limitations? Furthermore, there are situations where there is an express prohibition to go into a particular area, and yet you can still be held liable if a person goes into that area. And this situation arose in Ferguson and Welsh 1987, where the House of Lords held that in such circumstances the injured person would be a lawful visitor. And this is because the plaintiff had no reason or known anything about the details of the contract between the counsel and the defendant, and so they were reasonably entitled to believe that they could enter. So they must also know and be aware that they can't enter. You can't just have these express prohibitions saying you can't go into a particular area. In addition, we could look at the case of Dobbs and Michelle and Butler, PLC 2007, where a lawful entrant into the pub was ejected for drunkenness. So when they did come, they were a visitor because they had a permission to be there. But when they re-entered as a trespasser, because what makes you a lawful visitor, the point I'm trying to get across here is what makes you a lawful visitor is dependent upon time, space, and circumstances, and all the different factors will be weighed in when courts are trying to establish if a duty of care was owed you. Now, the Act also specifies a standard of care by which the duty will be assessed. So Section 2.2 states that to take reasonable care to see that visitors will be reasonably safe in using premises for the purposes by which he's invited to be there. So this also gives the idea that if you've come for swimming but yet you get injured doing something like cycling, then there might not be a duty there because you were only allowed to be there to go up the stairs and not slide down the banister, as in the words of Scruton L.J. And another key point to note is that the premises doesn't have to be reasonably safe, it's the visitor who has to be reasonably safe. So it doesn't matter if the electricity is dangerous, if that's not the reason, if the visitor's been given some kind of equipment to put on and to be there. It's the visitor that must be reasonably safe. Then there are situations of children, skilled visitors, warnings, and independent contractors, which the Act deals with specifically, and they are very, very specific to lawful entrance, and we will look at these individually in my next video. Thank you for watching.